Welcome to the ECGI 2021 Wallenberg Lecture. My name is Marco Becht. I'm a professor of finance at University Libre de Bruxelles and the Goldschmidt Professor of Corporate Governance at the Solvay Brussels School. But today I'm here in my capacity as Executive Director of ECGI. So before we get started, I'll give you a brief overview of what's on the program this afternoon. And I'll then introduce, and I'll also introduce the protagonists. So the first item of business is, of course, the Wallenberg Lecture, and I'll come back to that in a second. After the Wallenberg Lecture, we have the ECGI Working Paper, Best Working Paper Prize Awards, one for finance that's given out by Mike Burkhardt, the editor of the finance series, and the prize is actually given out by Elo von Tudden, which chairs the European Corporate Governance Research Foundation that sponsors the prize this year. We then turn to the Best Working Paper Prize in Law, and that's given out by Amir Licht, who edits the series, and the prize is given out by Roberta Bonsignore from Cleary Gottlieb, who sponsor the prize. Now, but we'll start, before we get to that, we start with the Wallenberg Lecture. So let me first of all tell you something about the Wallenberg Foundations that have given their names to this lecture, talk a little bit about the lecture last year, and then finally introduce the lecture this year. So first of all, those of you who are not familiar with the Wallenberg Foundations, I invite you to visit their website. The Wallenberg Foundations is a collective name to the public and private foundations formed by the Wallenberg family or established in memory of family members, and the foundations grant funding to excellent researchers and research projects beneficial to Sweden. And since 1917, they've given out about 37 billion Swedish kroners, over 11 billion in the last 5 years. So they're a foundation that fund science, and they also are linked to a family. So that is good. That, however, doesn't make them that remarkable. What's really remarkable about the Wallenberg Foundations is that they, from the beginning, have cared very much about their portfolios and the companies in which they invest. So they've never been a passive investor, but they've always taken a keen interest in the governance of the corporations that they invest in. They're very actively involved there. And many of the things that we are discussing today, long-term, engaged, responsible, purpose, all these kind of things have been really part of their DNA from the very beginning. So we thought it was very fitting that they would give their name, and they kindly agreed to give their name to the annual lecture of ECGI that is delivered by one of our outstanding research members. So last year we were supposed to kick this off in person in Stockholm. Now you all know what happened there. You will find, and Elaine is going to put a link in the chat, you will find an interview with the chairman of the Wallenberg Foundations, Peter Wallenberg Jr., that was conducted online last year. And the benefit of this is that because it couldn't happen in person, you can actually watch the interview and he can tell you much more about the foundations. Now, the first lecture last year was given by Oliver Hart, and Oliver needs, of course, no introduction. And he talked about the trade-off between exit and voice. And that was last year. And if you remember what happened this year, we, of course, first had engine number 1 at Exxon, which was, of course, an outstanding example of voice and engagement. But just last week, we had a BP, one of the largest pension funds in the world, announcing that they're completely divesting from fossil fuels because they have decided that they can't get anywhere with engagement. So one feature of the lectures is that they have, scholars are said not to always have a relationship with reality. I think so far we've really been spot on. Now, which brings me to the lecture today, which is going to be delivered by Roberta Romano. I think Roberta needs, you've seen her CV, in that sense she needs no introduction. I just, as a personal note, like to encourage you to type her name into Google Scholar, and you'll notice 2 things immediately. So first of all, that she's incredibly widely cited, and rightly so, more than 1,000 citations for many of her contributions, which is a lot in our field. The second thing you'll notice is that she likes controversial titles. So you have SOX and the making of quack corporate governance, law as a product, empowering investors. One I particularly like, less is more, about investor engagement. And then, of course, her classic, The Genius of American Corporate Law. So Roberta is, maybe that's because she's a lawyer, maybe that's why she became a lawyer. She likes to take positions and she argues them incredibly well. Now, I think you will find that the lecture today, which has the title, The Iron Law of Financial Regulation, will not disappoint in that respect. And you will hear that you of course know the saying, never waste a good crisis. I think Roberta will give you a perspective that might be unusual on this particular topic. And I'll introduce the discussant, Franklin Allen, after Roberta's lecture, and then there's also going to be time for Q&A. So Roberta, over to you. And thank you again for agreeing to give the lecture this year.
Thank you very much for those kind words, Marco. It's a great honor to be giving the Wallenberg Lecture. They are a wonderful foundation. I did look at their website, and as is the ECGI. So I was delighted to agree when I was invited, and especially given our prior speaker, it's really a great honor. I'm going to talk today, so let me just give a roadmap of my lecture. I'm going to explain what I mean by the iron law of financial regulation, and then I'm going to try to focus on providing preliminary findings on the empirical foundations of the iron law. I do have, as you'll see, I think there are some shortcomings here in crisis legislation, as Marco has suggested. I do have a proposed solution. I don't think I have time for that in my prepared remarks. And this is really directed at the governance of political institutions, in particular the US Congress, more than private corporations, which has been, of course, our major focus. But if there's time and interest, I'm happy to say a word about that during the Q&A. So let me start by giving, I guess, before I give an overview of what I mean by the iron law, I should say how I got the term iron law. And I'm using it by analogy to the work of the German sociologist, Robert Michaels, who set up or originated or formulated the iron law of oligarchy, which is that all complex organizations, no matter how democratic in origin, will be governed by a hierarchy, an elite of oligarchs. His example was the German Socialist Party. And I'm invoking that as an analogy to depict what I contend is a behavioral regularity in response to financial crises. Just as he found hierarchy ubiquitous, when financial crises occur, legislators will respond in a discernible pattern. Now, my focus here on this very provincial, so I'm focusing on the US, but I do think that there are some parallels, but we find this in many other nations as well. So the iron law is composed, or there are three factors that I'll argue contribute to the iron law of financial regulation. And so let me just give this overview, and then I'm going to spend a little time to flesh them out. So the first has to do with the environment in which financial institutions operate. There are two types of uncertainty I will emphasize: radical and dynamic uncertainty that renders regulation difficult in the best of times. And let me emphasize, when I say financial institutions, my focus here is on institutions, banking and banking regulation, and not on financial markets or securities regulation. So that's the first factor, is the nature of financial institutions and the markets in which they operate. The second, I'm going to take Frank Knight's phrase, pithy phrase, human nature as we know it. And that's that in the wake of a crisis, legislators will enact legislation that invariably increases regulation despite being at an information disadvantage regarding what to do when they're acting. The third contributing factor to the iron law combines with the first two, that means in the first two, since we don't quite know what's going on and we've got a lot of uncertainty here, there are inevitably going to be some errors being made in the policies that are being adopted, but financial regulation is sticky. And so the result, which is my iron law, is that we get a piling up, at least in the US, of statutes on top of statutes, laying regulations upon regulations, that creates a regulatory ratchet, producing cumulatively a complex and opaque regulatory apparatus, which results in heightened legal uncertainty, what can be costly unintended consequences, and a low level of adaptability. So let me try to give some flesh out these factors. So the first thing I'd like to note is that over time, recently, we see increasingly large, complex, and interconnected financial institutions. And so let me just sort of give one picture. It's a little old, but it's the best sort of graph available. And this is just giving a measure of complexity in terms of the number of subsidiaries that major bank holding companies in the US have. And if we look at the chart, in 1990, there was only one that had over 1,000 subsidiaries. And we come to 2012, right? And there's many that have over 1,000 and some have over 3,000, at least two. So quite complex. What does that mean? That means that the increased scale and complexity is going to make monitoring risks by managers and regulators difficult. It's not that they don't recognize this. So one of our members, Renee Stoltz, has a very interesting paper where he finds that the more complex a bank is, the more likely they were to have risk management committees before they were required by Dodd-Frank. But we have to sort of put this in context, and there are two types of uncertainty that bedevil these markets in which they operate and institutions that make it increasingly or incredibly difficult to monitor risks. And the first I refer to as radical uncertainty. So here I'm taking Mervyn King's term for what many of you are probably familiar with of Knightian uncertainty. And that is that there are future states for which we just cannot assign a probability as we cannot imagine them. Right? And I prefer King in that Knight focused on entrepreneurs and their taking of risk and the profit function, whereas King sort of extends this to thinking about financial systems and the economy in general. So there are just some unknowable unknowns, which is going to make it very challenging to monitor risks by the managers of these large corporations and the regulators that supervise them. The second type of uncertainty, which makes the problem even greater, I'm using the term here for dynamic. This is well recognized in the literature, and the idea is that regulated entities respond to regulation. So you've probably seen this in other areas, this the Lucas critique in macroeconomics, or the Goodhart's law that's used in social sciences. And I took the terminology that I liked best, which was from the terrorism literature. And this is a literature that's thinking about, tail risks, remote risks, and the difference between thinking about earthquakes and thinking about terrorist attacks, both equally, large scale, but very remote events. And if we have regulation to improve the construction of buildings to be resistant or more resilient in the face of an earthquake, that doesn't affect the probability of the earthquake occurring. But when we regulate, what you can bring in on an airline, right, we might sort of prevent some types of 9/11 terrorist attacks, but that's not going to prevent them because they're just going to come back and do something else that can well be unexpected. And so the idea here is not that regulators don't know that the efforts of the regulated entities, your financial institutions, are going to try to undermine the regulations, but they're in ways in which we cannot readily anticipate. They're not necessarily going to be linear, and we don't know then where the new risks will emerge. So to repeat, we've got radical uncertainty and we've got dynamic uncertainty, that the responses to regulation will confound the effectiveness of regulation. And so this creates the challenge that even in the best of times, to predict the impact of legislative and regulatory action where future problems may lie is going to be very difficult. So that's the first factor. The second factor I'm going to bring in is legislators' response to financial crisis. And so again, this is the idea that Congress invariably enacts major financial regulation in response to a crisis. As Marco said, this is a well-recognized event that political actors may see as to their advantage. I think we don't need much of a motivation or positing what the motivation of congressmen, members of Congress or legislators have. I can take the simplest from political science that legislators like to be or seek to be reelected. And we think about a crisis, the media covers banking issues, what's going on a lot. People also are seriously impacted by this. And along with the media, there's a popular demand that government do something. And there's an extended political science literature with theory and empirical support about how salient issues and things that the public are concerned about influence what members, legislators or government officials do in response. And so when we put this together, this is just the electoral concern makes Congress members or legislators seem to feel there's a necessity to do something. And this opens a window for what the political science literature terms as a policy entrepreneur. And these are people who invest time and resources to sort of promote policies that they think will be in the public interest. And they can promote their policies as a ready-made solution. So Congress members of the legislature are looking around, they need to do something fast. So they need something off the rack, right? That's it can be readily adaptable. And the successful policy entrepreneur is able to take sort of a policy that they prefer, that was developed in a different context, maybe years before for a different purpose, but they can connect their proposal to the issues at hand to say, this is going to resolve some of the issues that we think are contributed to the crisis or what's going on in the crisis, and get that not only on the agenda, but successfully enacted. So the challenge then though here is that there's a need to act when there's a paucity of information available regarding what affected the crisis, what were the contributing factors, let alone how we should devise an appropriate response, even for the most conscientious public servant. Right. The third factor then that we have to think about in conjunction with that is the US system of checks and balances creates many legislative veto points, from the committees that are institutional and constitutional ones, from the Constitution requiring 2 chambers and the president's agreement, to the institutional ones where there are committees that release things to the floor and a variety of things. And the point, of course, this was purposeful, is it makes Congress unable to respond nimbly to legislative and regulatory error. So a crisis may get them to act, right? But once they've acted, there are lots of institutional constraints that prevent them from revisiting and reassessing, not the least of which we should add just the capacity of time and resources to address when you've got lots of things that are going on. Now, of course, this affects all subjects of legislation in the United States. These are institutional factors, but I would argue financial regulation can be thought of as especially sticky. It's technical, so legislators and the public will cede that to administrators, our expert agencies in normal times. They don't pay attention to it because it's not affecting them, and they don't know much about it. We can also add, there are cognitive biases in this regard. So David Hirschleifer, behavioral financial economist, notes that sort of in thinking about financial regulation, there's losses are salient. So this isn't just common, but he puts it in the context of let's think about derivatives. And so the rogue trader who brings down Barings Bank and creates big losses, that's very salient to people. And they say we need to regulate derivatives. But there are the benefits of regulation that stymies sort of some innovation that could be beneficial. Those are invisible. And so he says that creates this bias to regulation that's sticky because of the way people conceive of losses and benefits. Another important thing here is that regulation creates new constituencies then who have vested interest in maintaining this regulatory status quo because they've had to invest in substantial, make substantial investments to comply with the regulation. Right? Eric Potashnik's done this study to find out what legislation appears more durable, and excluding sort of the problem that you could have some exogenous shocks that undermine legislation. If you don't have them, the more invested there are in these new constituencies, the more likely the legislation lasts. And if we just think about the most recent government response, the Dodd-Frank Act, it imposed considerable costs. Michael Simfinick and Zhang have done a study sort of that tries to calculate how substantial the costs were imposed on a subset of financial institutions from Dodd-Frank. And I just have a quote from Lloyd Blankfein to sort of make this point. The former CEO of Goldman Sachs. He says, "We hear people in our industry talk with a sigh about the burdensomeness of regulation. But in fact, in some cases, burdensome regulation acts as a bit of a moat around our business." So, if you think about just economies of scale, large firms have the capacity to comply, and it's much harder for small firms and new entrants. And so they have an interest. Now, I'm not saying this is always the case, but they do have some interest in maintaining the regulatory status quo. And the last factor we would add here is sort of the regulators, whether we want to call it a cognitive bias or risk aversion, they have incentives to favor the status quo as well. So the challenge, though, here is that given the dynamic nature of financial markets and financial institutions and their innovations of products, as the environment changes, we're going to have new products and emergent new risks attendant on these products. But there's little institutional incentive to revisit and revise regulations that are ineffective, that they're not doing a job against new risks that have emerged. So the consequence then, I'm going to argue about these factors, given the paucity of information about causes of the crisis and hence apposite solutions when enacted, crisis-driven statutes are likely to contain at least some problematic or inadequate provisions. This must-pass nature of legislation provides an opportunity for adept policy entrepreneurs to have enacted or to obtain the enactment of longstanding initiatives that may only be tangentially related to the crisis. In the dynamic, uncertain environment in which these firms operate, provisions that are appropriate when adopted may well obsolesce. So even if they didn't have some problematic or inapt provisions at the start, some of these provisions may well obsolesce or have unintended consequences while new products are generating new risks. But the institutional stickiness or scarcity of legislators' time, and I should say scarcity of legislators' time and resources, regulators' biases, prevent a responsive administrative self-resolution of regulatory errors that are generated by crisis-driven legislation. And there's little external impetus to adapt or act. Maybe eventually you might get some legislative response, but it takes a very long time to get that. So what I want to do for the rest of my time is I'd like to sort of provide, which is what I've been working on, some empirical foundations for the hypothesis I just laid out, my iron law of financial regulation. So the first thing I want us to think about, when we're thinking about what I've stated, I said Congress enacts major legislation after crises. Is that true? So I need to identify what a financial crisis is, and I need to identify what is important legislation. And rather than do it from scratch on my own, which we might think I'd be biasing the situation, I have decided to identify these from the work of other experts. And so for identifying financial crises, I've taken the work of Reinhardt and Rogoff, who have done the most comprehensive of the narrative approach. So the main approach that economists use to define crises is a narrative approach in which they look at historically at sort of things that have affected or measures of financial distress, such as increase in loan loss, losses on loans, and bank failures, in conjunction with government interventions, such as subsidizing failed banks or changing various policies of the lender of last resort and the like. And so there's a set of that. Of studies that use this approach variously. The benefit of Reiner and Rogoff is not only it's got the longest time frame on which they look at this, and these are multi-country comparisons, not just the US. They also provide start and end dates. Most of the studies only provide start dates, but since I'm talking about crisis-driven legislation, I need an end date as well. There are one or two studies that look at stock prices, some of them not really trying to look at financial crises, but trying to identify after a stock market crash, that we go into a financial recession, right, or a depression. Of course, that's why we're worried about financial crises, because of their effect on the real economy. The reason why I, again, opt for a narrative is there's been this explosion post-global financial crisis of work that's trying to define a financial cycle compared to a business cycle. And that literature suggests that stock prices are an unreliable predictor of crises. So the financial cycle literature finds that in a financial cycle, in particular variables such as credit expansion and another financial variable, housing asset prices that are houses, they peak and they're most often followed by financial crises. These banking crises and stock prices are not. I am going to start my time frame for looking at or trying to look at the Iron Law from after 1913. The Federal Reserve Act of 1913 created the central bank, or the Federal Reserve System, that transforms the banking environment. In fact, that was one of the reasons it was created. There had been central banks already in European countries. And the period before then, which is referred to as the National Banking Act, saw a large number of financial panics and banking crises, very frequent. And in fact, observationally, thereafter, there were not very many. And so let me just, this is just comparing them, but I'm just going to say the 4 financial crises that I'm using that they identify is 1914, the Great Depression, 1929 to 33, what we refer to in the US as the savings and loan crisis of 1984 to 91, and the global financial crisis of 2007 to 2010. Right. So that is going to be my, that is my time frame for the crises in my series. There aren't a lot, and I'm going to come back to that question. All right. Second, I need to identify what are major statutes. So fortunately for me, the Federal Deposit Insurance Corporation has on its website a list that it identifies as the most important banking statutes. Right. It's a list of 30. It's actually got 32, but since I'm starting after 1913, there are 30 statutes that are applicable. I have to sort of ask, well, should I include everything on their list? And political scientists in the US have engaged in what is referred to as the Policy Agendas Project, which seeks to sort of define a set of subject matters of policy. And there's 20 subject matters, and there's like 220 that are subcodes. And they have then codified all public laws since 1948 in the US, and their subtitles by these codes. And these data sets are publicly available. The political economists who started it were trying to look at important laws, and they were focused on what a publication called the Congressional Quarterly Almanac. It's kind of like an inside politics publication, but what it does is it covers activities on Capitol Hill. And its annual edition will describe provisions and the content of what it thinks are interesting or important laws that have been enacted in that session, and they code them. And so the codes that I'm going to look at, sort of decide what are the statutes to use, are the coding for what they say is a subject matter of banking regulation and also housing finance. Right? And that's because if we think about the crises and what I've just mentioned about financial cycles, mortgages, which banks lending to people for their housing is an important part of this. And so to get at sort of laws that would be directed at that might have to do with my Iron Law, those are the categories that I'm going to want. And there are 27 statutes out of that 30. We should note that come in, these databases start in 1948, and 3 of my statutes precede that. There are 2 from the Great Depression and the McFadden Act. So I've got 27 statutes. And the vast majority, if I include a general code for banking regulation, they're all under these codes, right? But there were 3 that were not. And so those 3 that are ones that I eliminate. And that, sort of just to mention one, was the Sarbanes-Oxley Act. We can understand why that's important. It imposed a large number of governance costs on all public companies, and banks are public companies. But it's not related to banking in particular. That followed an accounting crisis. And it's also not regulated by banking regulators. The SEC and a newly created accounting board are the ones that have the jurisdiction. So I've basically eliminated those those particular statutes. I have the wrong table that this is going to, so I'm going to, I'd like to show a table. I'm going to have to show another table that doesn't really do what I want to do. But this is just the statutes on this list and the code. And all I want to point out, or if we take a minute, I'm going to just open that. So this table shows the banking laws from the FDIC list that I'm using in conjunction with the dates of the financial crisis of Reinhardt and Rogoff. And we note that there are statutes enacted, multiple statutes in the wake of these crises for 1929 to 33, the Great Depression, for the S&L crisis, and for the global financial crisis. And of course, there are statutes in other periods. I'm going to come back to that, but also the July 1914, the 1 month financial crisis on Reinhardt and Rogoff, although not in other studies, does not. So let me sort of note is that 1914 crisis that doesn't have a statute an anomaly? Is it, you know, of course, in finance, we use anomalies for things that we can't explain, right? But the question is, does that undermine the iron law completely or not? And let me just say a few things about the crisis. Now, of course, it's of short duration, so that would be an easy answer. But so was the 1907 crisis. And so that's not a sufficient explanation because it was followed by legislation in 1908 that I'm going to come back to in a minute. So, so what might say why was this included is short, and shortness isn't the answer. Now, the 1908 statute is an interesting statute. It was time delimited, so is what we might refer to as a sunset or a temporary statute, and it gave the Treasury Secretary the authority to expand the definition of collateral that they would accept in a crisis from a bank that, you know, is one of the, you know, activities of a central bank that gives the banks liquidity and prevents the crisis. It also, though, created a commission, a national commission, to study whether a central bank should be established. So people, there was a debate in Congress at the time, although people understood it was being, you know, other countries had them. It was several years thereafter, but that commission did recommend establishing a central bank. The 1912 presidential election, that was one of the debated issues. Both parties had different proposals of how to create the bank. After the election in December 1913, the Federal Reserve Act, as I mentioned, was enacted. The Fed had not organized itself at the time of that crisis that began in July 1914, and the Treasury Secretary used his authority under the 1908 statute to stem the panic. Reinhardt and Rogoff characterized it as a banking crisis was avoided by flooding the country with emergency currency to prevent hasty withdrawals. So we might say, since it was avoided, why is it on their list? And obviously it's on their list because crises are defined by government intervention right into the banking system. But my argument here is, so why don't we see legislation in this period? And there are three things to note. Well, people expected the central bank to resolve crises. That was a highly salient event when the statute was enacted just 7 months before. It had been debated in the presidential campaign. A majority of the 1914 incumbents who were voting on that statute had been in office in 1913. The New York Times ran 10 editorials on the act in the month of its enactment in December, and 48 in 5 months pre-enactment. So there's a lot of publicity about what was going on. And I'm going to show some data subsequently about sort of the statutes on my list. And although there's a lot of coverage of these crises, not as much as the Federal Reserve Act's coverage. And so the effectiveness of government action, along with the salience of the crisis solution that had just recently adopted, we can argue alleviated public and media and legislators' perceived need to do something additional and acted under statute. So that would be my explanation for why I think that having the other three longer crises having statutes enacted is something that's useful, or at least to me, supports the iron law. I should note, I neglected to say, what am I defining as a crisis-driven statute? So it's pretty clear that would be a statute enacted during a crisis, but I use as my end period 2 years from the end date of a financial crisis. And that's basically because the congressional session lasts 2 years. So if they weren't able to pass it in the first term of the session, even though I'm saying it's rapid, this will cover it. Does this have much of a difference? There's only 2 statutes on my list of statutes that fall within that period. That is 2 years from the end. The Banking Act of 1935, what did it do? It made permanent the Federal Deposit Insurance Corporation, which was just a temporary entity to resolve banks in the 1933 Act. So clearly related. And the other one is the RTC Completion Act of 1993. RTC stands for the Resolution Trust Corporation. That was an entity created in one of the other S&L responses to resolve S&L's, the failing savings and loan institutions in that crisis, and that statute gave it more authority and more cash to resolve them. But I could exclude them and just do 1 year after the crisis, and none of the results I'm going to report will make any difference. All right. So let me just note one sort of thing that I did look at just in general to be thinking about the association between statutes and crises. And I just did a simple runs test, right? That is, looking at the pattern of a sequence of events, so like coin flips, and is that pattern random, just a haphazard pattern, or is there a more discernible pattern? And when we look at the crisis-driven statutes, it's actually significantly different from just what we would think, what a random correlation or association between years and statutes is. It's very significant, almost 5, a Z statistic of almost 5. When we look at the non-crisis statutes, completely insignificant. They're just haphazard in this. Obviously, this is not meant to show causation, but it suggests that there is an association between legislation and crises, that there isn't a random pattern, just a random pattern in the runs as there is for statutes enacted in more normal times. But when I have to sort of come back to my hypothesis, so of course, it's legislating after crises, but it's also doing that not after crises. So the question is, do crisis-driven statutes differ substantially from non-crisis-driven statutes to get at what I'm talking about in the iron law? So here, I'm going to look at some, again, measures that are already in the literature and text-based measures. One is for the extent of regulation, and the red in this slide is showing the ones that are statistically significant, but I'm going to show my table in a minute. But restrictive words, so there's a literature that thinks that certain words are thought to impose binding constraints on firms as a proxy, for regulation. So that there's that set of 5 words. I'm also going to take a look at complexity. And there's a literature that, a paper that they say, let's look at the idea is that we're going to look at computer software programming and what engineers think makes a software program, an algorithm, complex. And that's conditional words, that you have nodes in a tree that you have to make decisions. And the more branches there are in this tree of conditional decisions, the more complicated a program is. And so we can look at conditional words that require decisions. And there's actually a manual that the Senate publishes about saying, here are words that you should use if you're going to have a condition in the statute. And the last thing I'm going to look at is delegation, the extent of delegation here. And this is a measure that I adapt from work by political scientists Epstein and O'Halloran, that using those Congressional quarterly Almanac summaries of statutes, combine the number of provisions, the number that certain words to use that are delegating to agencies, and a number that are constraining agencies, because you might delegate on one hand and then restrict them on the other. Some factor analysis goes in, and there's a way to sort of come up with an aggregate measure of the extent of delegation. Now, my iron law has a direct hypothesis for text-based measures of regulation. There should be more of them, right, in crisis-driven statutes than not. So I'm going to look at one-tailed tests. I don't have a strong hypothesis for complexity. Maybe just the nature of financial matters are inherently complex, and then no matter when we're legislating, they're being complex. And that could also be then with delegation. If it's very complex, we have to delegate no matter what. But we could put a positive gloss on the iron law. If there was more delegation in a crisis-driven statute, then it might mean that legislators, well, they're aware of their information problems, and they're seeking to compensate for a poor information environment by delegating more to an agency that will, when it implements the regulations it's telling them to do, may have more information. Okay, here's a table of looking at, So why is it going to that one? So I'm having a problem with my links here. I'm not sure why that is the case. So I'm going to have to, again, go to, just go to this. Okay, here we are. So this is, I'm going to compare the statutes enacted. So my 12 statutes that are crisis-driven statutes, and then my 15 that are not. And as I said, the first two are one-tailed tests. So, to be honest, they're so large that even a two-tailed test would be. And so for those of you more technically minded, you might say, you have a population, right? Because I've argued this is all the crises and all the statutes. So why am I even showing statistics? So my answer would be, well, the well-known proposition. If I show them, you'll say I'm technically ignorant, but if I don't show them, you'll say I'm hiding something. So let's just look at them. Although, with these kinds of magnitudes of difference, right? 1,200 words versus 300 words, I don't need a statistical test to say they're different. I should also note here, though, well, there is a small number of observations. So obviously my number of crises are very small, it's 4. And, okay, I'm looking at statutes, so it's more, it's 27. That is still not a very large sample. So you say, so why, why should we draw anything from it? And, my response would be that, we have to make a judgment whether we're going to work with limited information. Is that better than no information here, or unanchored intuitions, I would say. I'm going to view this as a Popperian approach to what I'm doing. As some social scientists have put that approach, they would say that we're going to acknowledge, we can never really prove a hypothesis. Rather, we can test them on our available cases and provisionally accept them in the absence of contradictory evidence. And in the end, basically, my argument is we have to work with the best information that's available while maintaining an open mind about what to draw from the results, that I'm presenting to you. So in any event, there's a large number of differences between these statutes. As I said, these are two-tailed tests. I use a one-tailed test for complexity and discretion because, as I said, it could just be a function of the content of the law. The statutes enacted in the wake of a crisis are also more complex. Not surprisingly, these things are highly correlated. The number of total words in the statute is highly correlated over 0.9, with the restrictive words in it, and complexity and restrictive words are also highly correlated. Delegation is not significantly different, although in the direction of having slightly more. I should note that in the Epstein and O'Halloran paper or book, they don't give enough statistics for me to compare these directly, but they do sort of say the statutes they think have a lot of delegation have a measure that's 0.48. And the statutes that have very low level is 0.05. So these are not high, but they're not the lowest. And so I suppose I might have thought that, or we might think that they defer all the time to agencies in the banking context. And though it looks like they do defer to them, but not a lot. So they're not more deferential to banking regulators. They're more deferential in many other fields, which is an interesting finding. So, of course, you might say my hypothesis is not really what's in the statutes, but it's in the regulations. And so here, there is a public database that uses those 5 words that I mentioned and looks at everything in the Code of Federal Regulations and by title to see the changes of the growth in these words. Now, this public database starts in 1970. This is a picture of Title 12, which is the banking title, of those words over time. What I've done is I've gone back and backfilled this data set back to, since my period starts in 1927, it's my first statute. So I backfilled all those 40 odd years. And I wanted to see, well, how does my program work with theirs? And when I compared 1970 and 1971 for an overlap, I found that they didn't exactly align. There weren't big differences, but so I've started now doing this going forward. This is a tedious mind-diddling project, as you might expect. I've been working on this for over a year, and I'm only up to 1998. So my data on this and testing whether, of course, it's much harder to sort of figure this out because the administrative process takes time. So we're not going to get sort of the statute tells a regulator to do something. If they're going through the full notice and comment, it can take years, and we don't know how many years, and there's some estimates and the like. So I'll be looking at this. So when we're looking at this picture, this is not my data, so this is really preliminary. The arrows are showing the first and last year of the financial crisis as dated by Reinhardt and Rogoff that occur within this period. So this is the S&L crisis, and this is the global financial crisis. The red lines are the first and last statute of the FDIC list that I'm calling crisis driven around this. As we can see, of course, the trajectory is up, which is consistent with the law. This huge steep increase is the response to Dodd-Frank. And it took about 5 years. There's a law firm that tracks the regulation, and you don't get more than half of them until several years thereafter of being adopted. This we can see is much greater increase. This little dip is most likely associated in 1999. The Graham-Leach-Bliley, one of our ordinary times important laws, had many deregulatory initiatives in it. But the thing that I would emphasize here, even if we have some deregulatory initiatives in normal times, they are overwhelmed and swamped by the progression of an upward trajectory of regulation. This 1970s is consistent with the Great Society. If we were to look at all regulations and not just banking regulations, we'd see a big increase in this period just in general. Obviously, normal regulations can increase them, but as I said, I'm not going to use this because I need my own database, and there's a little differences in where the little blip might be. If we're going to test slopes to see, do we get an increase? But overall, in looking at this, it suggests that we do have increase is in this. And my last slide I want to sort of speak to is, can I come up with anything that accounts for the difference that I'm finding between crisis and non-crisis driven statutes, apart from obviously the economic circumstances in which they're enacted? So I'm going to look at two things, one related to the iron law. So I've said that salience matters in that. So is there a difference in salience of banking issues in the one context and the other that might lead to more desire for more regulation? And so I look at the traditional literature, things that people look at, which is front pages of New York Times. I also take the Washington Post here, editorials. I'm going to look at banking issues as well as the specific legislation that's on my list. Congressional quarterly analysis, people say if they have a certain amount of lines, it means it's more important or more salient. State of the Union addresses of the presidents, do they refer to banking issues or not? Since what the president thinks can also affect perhaps what's on the congressional agenda, we think. Gallup poll for most important problem, public mood measure where they survey people and then they say, they put them on a spectrum, and the higher numbers are more liberal, which are associated with support for government. And just quickly, so some of these databases are in that policy agendas project. And so I filter them using those codes that I found in the statutes. But you have to read every story because it might be a banking regulation code, but then you look at the article and it's an employee of a bank suing them for racial discrimination. That's really not banking regulation. So I have to screen them. And I also check, the white collar crime, security, some other codes. I check them to see, am I missing a lot? And it turns out I'm not missing any. I'm choosing one. The main thing I want to point out here is some of them are just my own, so, they don't have a PAP database, but we find, again, the magnitudes are hugely different between the statutes enacted in the wake of a crisis and those that are not with respect to the salience of banking issues and the laws themselves. And they're all significant. The presidential address, if we just have an indicator variable, it's marginally significant. But if we look at the percentage of the total quasi-statements, this is a database that looks at a sentence or a colon. So that's called a quasi-statement. And then this is again a PAP database. So I look at banking codes. And the percentage of banking codes out of the total statements is significantly different. Again, a big magnitude, but the total amount of statements are not. So this is suggesting that the difference is not just because they're longer speeches, but because of the subject matter. Just go back for a minute. The second thing that I'm going to look at, well, what about the legislative environment? Is there something different about what's going on in Congress when they're enacting a statute before, in a normal time versus after a crisis? And I look at things that people in the literature have said may affect whether or not you see an important law, like unified government, as opposed to the president and Congress are the same party. And when they're divided, we might think, well, we don't get as many important laws. That's actually debated in the political science. Famous book by David Mayu argued there doesn't matter. Who's the majority party? How big is their majority? Are there party line votes, or also called unity votes, where the majority of one side is on one side and the minority party's majority is on the other side of the issue? And then polarization, how politically different are the two parties? We're basically a two-party system, unlike many European countries, and a measure of what these political scientists call the legislative capacity of a chamber to enact a major initiative. And this combines the strength of the majority with how cohesive the majority is. So whether or not and you have votes of party lines that the majority party holds together and the minority parties on the other side. And sort of as a baseline about you need a minimum amount to get legislation passed. How higher are you on that? And it's done for the House because the House turns over, every time there's an election, whereas our Senate is staggered. And just to go back then to these measures, right? Whoops. That was just the Gallup poll to show, I guess, I didn't show that the mood is more, although there are small numbers, the mood is more oriented to wanting government regulation in the crisis periods than not. But let me just sort of conclude showing this slide that most of the differences are not great, although there's a higher probability or a higher percentage of Democrats in the Congresses that are enacting statutes in the wake of a financial crisis than the others. They're not significant, but two things are significant. One is the capacity to pass major legislation is much higher, right? It's above the thresholds that they say are the thresholds that are important for the crisis-driven statutes than for the non-crisis-driven statutes. And another thing that actually completely surprised me and was counter to my intuition, there are a lot more party line votes in the context of crises, right? And one would have thought this is like, as I'm arguing, well, legislators, they have to do something. This is like motherhood and apple pie. They should all be, voting, unanimously for these statutes. And that's not true. Although the Senate is much less likely. There's in the Senate had one vote on a non-crisis statute that was a party line vote, none in the House, but they're all in the crisis-driven context where you see this. And, I did sort of say, well, okay, do these people lose? And so I did check on, what's the turnover of the people who voted no, and it turns out, no, they are not more likely to lose than the people who voted for it. Obviously there are many things that go into these things like waves of a party and a variety of local issues. But I should have thought, if we think about this, we wouldn't expect legislators to commit political suicide. So if they're all voting on the other side, then obviously they didn't think it was going to affect them. So that was something that was actually, I didn't predict that result. But to just conclude, right, the data support the iron law hypotheses that Congress enacts major financial legislation in the wake of financial crises. Crisis-driven legislation differs significantly from legislation enacted in non-crisis environments. There's greater textual measures of regulation and complexity, but not greater amount of delegation. There's greater regulatory content in crisis compared to non-crisis driven statutes what I've just said, that greater regulatory content would appear to be related to greater salience of banking issues before they're enacted, as expected by the iron law, and to a lesser extent by differences in the legislative environment. And the data are suggestive that, so this is more preliminary than the others, crisis-driven legislation acts as an accelerator of regulation, as it's followed by increases in growth of restrictive regulation that is not reversed by subsequent deregulatory initiatives in legislation enacted on occasion in non-crisis times. I've presented to you my law and what I think are shortcomings in crisis-driven legislation. And as I said, I have governance recommendations for Congress, but that's probably for another day. Thank you, and I look forward to Franklin's comments.
Thank you very much, Roberta. I think you've shown that the US Congress really never wastes a good crisis. In fact, you called it an iron law. And I think you also showed us what happens in these statutes that get passed. Now, to discuss this and the implications with this, we have Franklin Allen, who is a professor of finance at Imperial College. I also encourage you to type his name into Google Scholar, and you'll find that he is one of the global leading experts on comparative financial systems, as well as financial contagion and financial crises. And I couldn't think of anybody better to have agreed to discuss Roberta's lecture. And over to you, Franklin. And thank you again for agreeing to discuss.
Thank you, Marco, for that introduction. And thank you for asking me to discuss Roberta's fascinating lecture. This is based on, the lecture is based on chapters 1 to 3 of a book, as I understand it. And let me talk a little bit about those chapters that she talked about, look forward a bit. She didn't really talk much about some of the ideas that she mentions in the introduction, which I think are fascinating ones. So what she focused on was this idea that after you've had a financial crisis, and you get a lot of new banking regulations, and they're thought through without much evidence of whether they're desirable or not. And these regulations stay in place for very long periods. So you think something like the Glass-Steagall Act, we're talking about many, many decades. And the question is, given, as she's very convincingly argued, that there's this significant difference between the crisis regulations, which are the ones during the crisis plus 2 years, and the non-crisis statutes, what should we do about that? And as I say, she didn't really talk very much about that in the lecture, but in the chapters that she's got, she talks about sunset provisions as a way to control this kind of problem. And I think it's a great idea. If you have some period of years, I don't know what the optimal number will be, but maybe 10 or 15 years. So after people have had a chance to look at the effect of the statutes that were introduced in the crisis, and to see whether or not they work well, or whether they should be repealed, or whether they should be changed in some way. And I think it's a very important and appealing idea. So the overall theme of the book, as I understand it, is a very, very good one. Now, as Marco said at the beginning, Roberta takes a strong position and then defends it extremely well. And so she, of course, has done that in this case too. And I'm not going to critique the individual parts of the arguments that she made, but rather what I wanted to do was to give some broad brush kinds of comments about how to think about this iron law of financial regulation. Now, one thing which is not discussed that much, although there is this notion that there's a lot of banking regulation that's put in after crises. But I think one of the important issues is, what's the optimal level of banking regulation? I mean, basically, is there too much of it now, for example? Was there too much of it in the 1940s and onwards? What should we have as the optimal regulation? I think particularly post the 2007 to 9, or however you date it, crisis, the global financial crisis, a very important issue. So microprudential regulation of the basic sort, so checking on the risk-taking of banks at an individual level, I think is an important thing. I think we have to worry about, are the banks being managed reasonably well? Are they taking a lot of risks? And so the traditional kind of microprudential regulation, I think, does have an important role to play. Now, in the financial crisis, I think what surprised many people was systemic risk in a way we hadn't seen it for many, many years. And lots of the narratives of the global financial crisis talk about people taking lots and lots of risks and so on. It's not so clear to me that if you look at the basic evidence, for example, the papers by Wallenberg and Stultz looking at portfolios of bank managers and so on, and other evidence on their compensation, that they weren't necessarily knowingly taking risks. They did ex post take a lot of risks. And this, of course, is the issue of macroprudential risk. And the question is, how much can we do in terms of regulating macroprudential risk? Now, there are two parts to that. One is capital buffers. So, I think capital buffers probably do have a role to play. Quite how much that they should play is another question. The second part of macro-prudential regulation is about interventions in markets directly, particularly the real estate market. And I think that's a very important issue, but it's quite questionable as to the effects that those regulations have. You know, the other issue that this raises is, which Roberta sort of mentioned briefly in passing, which is that she chose the starting date as the start of the Federal Reserve System. And you know, what exactly is the role of the central bank versus ex-ante regulation? So, you know, if we look at the 19th century, traditionally, what central banks did about systemic risk was to intervene ex post. And, you know, the Bank of England was always quoted as being the exemplar of how effective you could be at that. And I think there is a big issue as to why we focus so much on ex-ante regulation, and particularly in the US. And that may be part of this history that pre the Federal Reserve, banking crisis happened all the time, of course. Afterwards, they've been less frequent, but they have been pretty dramatic. So I think there's a basic issue there, which is an important one. Now, this notion of how important is ex-ante regulation, I think is crucial. And again, I think it's important to think a little bit more broadly than banking regulation. So as Roberta said, she's focusing in the lecture and what she's written so far on banking regulation. But of course, it's called the Iron Law of Financial Regulation. And of course, the other side of the regulation is the Securities Regulation. And whereas I think many people would say the banking regulation was done badly and was subsequently, after many, many years, as Roberta argues, changed, the Securities Regulation was done rather differently. It was not done in quite as much of a hurry. It was done over many years, and it was structured in a careful way. It's been updated, certainly, but fundamentally, it's a development. It's an improvement. We haven't repealed any of these major parts of the Securities Regulation. So there's nothing like the repeal of Glass-Steagall. And many of these acts operate with changes, of course, but basically in a very similar way to the way they did then. So as a finance scholar, it seems to me they've done a pretty good job, much better than the banking regulation. And one of the interesting issues is, why is that? Why, you know, there was a lot of angst both at the banking system, but also at the securities markets. And why is it that they, on the securities market side, took such a careful, thought through approach and step-by-step approach about what to do compared to banking? And I think the other important aspect of this is that whereas securities regulation has been copied around the world, so most advanced countries' securities regulation is essentially based on the US system. That's not true of the banking regulation. So if you think about something like the separation of investment and commercial banking, that was a very American phenomenon. It wasn't copied in Europe. And I think trying to understand these differences between the banking and the securities regulation would be extremely helpful. Now, to take this one step further, I would argue that one of the reasons that the US financial system has been so successful in driving economic growth over the long term, over many, many decades, is that we had bad banking regulation to a large extent, relatively speaking, and we had good securities market regulation. And what we see is that the US financial system is radically different than most European financial systems. It's much more securities markets based. It's much less in terms of banks. So if you look at things like bank assets to GDP, US is much, much lower. American banks are big because it's a big economy, but the actual impact of the banking system in terms of the financial system is much smaller than markets. So bond markets, for example, are extremely important in the US, particularly non-financial corporation bond markets. And that's not true in many other parts of the world. And similarly, the stock market plays an extremely important role. And so I think that's a very important issue. Now, you know, if you take the opposite end of the spectrum, so if you think about Germany, it's got a banking system which it still plays an enormously important role in its economy. And one of its big problems, I would argue, which is that their securities market regulation is way behind most countries in Europe, let alone in the US. So if you think about, you know, if you go back to the financial crisis, if you think about the Porsche Volkswagen, essentially short squeeze, which, you know, BaFin didn't handle well. And then you come to the present day and we go through Wirecard and, you know, so many other scandals in Germany on the securities market side and the problems that BaFin has had. And I think that's one of the, you know, one of the big problems that Europe has. So we have the Capital Markets Union, but it's not going anywhere. I think part of this problem is that the securities market regulation in many parts of Europe just doesn't work well. They haven't really caught up with the US, even though those acts that I was talking about, you know, took place many, many decades ago. So, you know, just to take one example, if you think about the US, what are the dominant firms? Well, they're firms like Google and Facebook and Amazon and so on. Not Europe, we don't have those. The only country that has those kinds of firms other than the US is China. And I think these kinds of regulatory issues about markets versus banks and so on, and banking regulation versus securities market regulation is extremely important, trying to understand that. And I think this iron law is very interesting because it's not, as I say, I'm not a legal expert, so I could be stepping way out of line, but as a finance scholar or persons trying to study it, it is very interesting, these differences in these financial systems across the world. And that brings me to the next point. I think an international comparison would be very interesting to do. You focused, as you said, at the beginning on the US, but particularly in terms of the Great Depression, if you look at the way that countries reacted, they're very different. And the ways that they unwound these changes that they made after the Great Depression are also very different and took different time periods. And so I think, you know, this idea that you have that the iron law does provoke very serious reactions is very important in banking. So, you know, just to give some examples here, in France, basically what they decided to do was to nationalize the banking system and the financial intermediaries. And then over the years, they've undone that. If you look at countries like Sweden, for example, they didn't have nationalization of the banks, but they controlled what the banks did. So they had financial repression, and the government essentially, to a large extent, allocated where credit went to. If you think about Germany, banks were regulated, but they played a much wider role in things like corporate governance and played a very different kind of role. And I think that's an interesting aspect of this whole debate. And if we think back, you know, 20 years, a large part of the debates were how much should banks be involved in corporate governance, and with the house bank system in Germany and the main bank system in Japan. And then the other issue, which sort of is a mixture of this, is, you know, how much do you want to have a mixed banking system where the government controls some banks or financial intermediaries, and then there's a private sector and so on. And, you know, I think Japan is an interesting example of that. They've, to a large extent, unwound that. You know, even the postal bank is being unwound to some extent. In countries like Chile, something like Banco Estado, it is still a very important bank and plays a significant role in creating competition between the different banks. And even in the US, of course, we have the Fannie and Freddie and the GSEs, and so it's not exactly as though it's a pure private financial system. So there are a lot of issues there which are related to this iron law, I think. So different kinds of political reactions. Now, you focus on financial crises, but I think one of the big issues is that it's not just financial crises that cause big changes in regulation, it's other kinds of crises. And of course, 9/11 created a huge reaction, and a lot of that was in the financial system. And if we look at banking regulation today, I think a lot of it is to weaponize the dollar-based financial system. And a lot of that started after 9/11 with the Patriot Act and all the controls on financing and banks that created, but also this, I think it accelerated this tendency for extraterritoriality, whereby the US imposes its will on other countries around the world through the dollar-based financial system. And I think it'd be very interesting to discuss the iron law in relation to this extraterritorial act. So if you think about the big fines, most of it is things like BNP Paribas processing payments for Iran and then being fined 9 billion. And actually they were lucky to get away with that lower fine because they could have been frozen out of the dollar-based system, in which case they would have gone bankrupt probably. So, that's an important question. And, I think this issue of putting sunset provisions in should be applied maybe in other areas too, because things like the Patriot Act are going to be with us for a long time. And it's not so clear that it's that good an idea. And let me finish with another thing, which I think a lot of these regulations, particularly in banking, have led to, which is fintech. And I think if you think about much of what fintech does, it's essentially getting around regulations of various kinds. So, if you think about why is Bitcoin so successful? So, if you listen to read many people in the press, so for example, the FT often has columns about how ridiculous Bitcoin is and so on. And, when it went to 20,000 and then collapsed down to a few $1,000s, well, it seemed obvious that it's finished, and that was all a nice fad and bubble and so on. But then, of course, it went up again and went down again. And last time I looked, it was around 60,000, which is near the all-time peak. And there's a huge demand for these kinds of anonymous payment systems, which basically it's extremely difficult for anybody to control or regulate. And a lot of fintech is about that. So if you think about initial coin offerings, these ICOs, essentially it's done in a global market on the internet, and they can't regulate it. So, people say, well, we're going to regulate this, but it's actually very difficult to do, I think. And I think that's a big issue in terms of regulation going forward. And I don't think that was fintech so much a response to a crisis, but it's a response to the response to crises, in particular these attempts to enforce extraterritoriality. So let me just finish off. Chapters 1 to 3 are excellent, and I recommend them to you. One of the really intriguing things about reading of them is that there are many references to read more about this in chapter X. And so I'm very much looking forward to seeing the future chapters. So I recommend what's already there and look forward to reading the future ones. Thank you. Thank you,
Franklin. Roberta, do you want to, we have questions already. We have one question in the chat, but do you want to just briefly respond to Franklin?
Franklin, thank you so much for these very thoughtful and intriguing questions that obviously I have to think about. And let me just say two things, because actually I'm very interested to hear what the questions I we'd hope sunsetting might help us more about thinking out what is the right level of regulation. I have no idea. And the only thing is by revisiting these things, then one might get a better sense of, well, what's too much, what's too little. And I certainly agree with you with the latter part, that ideally we would sunset everything. And this is just saying, well, I have to start somewhere, and at least it's sort of more defined or focused aspect. And everyone should know the USA Patriot Act is on the Title III, which is the money laundering about banks and non-financial banks, is on the FDIC's list. And for consistency, although obviously it affects banks, since that is actually classified as a terrorist act, it's not in it. But I should note sort of the early money laundering acts are on the list because those are counted as banking regulation, even though we could have classified them as that. But and maybe it's the only rationale for not having it on is a lot of that was directed at foreign banks and bringing them in under the existing money laundering that applied to US banks. But I couldn't agree with you more that a lot of legislation we would be useful if we could sunset a lot more of these things. And the irony about the sunset of the Patriot Act, it did have one part that was sunset, which was on the sort of restrictions on on individual privacy and whatever, liberty, whatever you call it, the wiretap. But sadly, that was just rubber stamped and in the sunsetting. So sunsetting also has to be effectively set up to work. But anyway, thank you so much for your comments. They're great comments.
So I have one question from Paola Perotti, which is actually quite related to what Franklin said. So she says, "Dear Professor Romano, what a compelling lecture. Thank you. I wonder to what extent the effect you describe in the US is further compounded by similar legislation implemented in the EU and Japan. Most banks and financial institutions are subject to regulation on a global scale."
So I think obviously the Basel regulations that have to be implemented by formal rulemaking in the US have some impact. Congress has allowed, there's a statute that allows regulators to actually do that and to coordinate, because otherwise one might be worried about whether they have the authority to do that. So they are allowed that. I've argued, I need to think more about this. The Dodd-Frank Act did sort of go beyond, or had some things that related to wanting higher capital requirements, or things that we think of in Basel III. I've actually argued, talking about Marco saying that I do provocative things, I've actually argued that there's a problem with having global harmonization in banking, that it can exacerbate systemic risk. Because if all the banks are hurting on the same, they're all doing similar things, that the regulation has incentivized them to hold the low risk weights. And it turns out that those risk rates were wrong, like on subprime, security subprime assets, then we have a global problem rather than a local problem. And that's really where I've thought about how international regulation comes in. So your question suggests to me that I need to think about how it works into what Congress does. I think, to be honest, Congress probably ignores a lot of what's going on outside the world, and just, and the policy entrepreneurs, they're just focused more on that than on trying to sort of coordinate our own legislation with the international regulations that are imposed on banks. But it's a good question. I need to think a little bit, think about that.
The next question comes from John Turner. So it's a long question, so I'll try to read it anyway. So it says, John Turner says, Franklin's point about fintech are interesting. We could make a connection to the financial engineering that created, in quotation marks, the global crisis mechanisms designed to get around the regulator. Should the study be expected to examine the relative complexity of the banking system over time? Question mark. One counter hypothesis might be that the lawmakers are merely playing catch up, having had that complexity thrown in their face? Question mark.
Well, I am sort of going to try to measure complexity in the CFR. So that's on the public database didn't do that, and that's another reason why it's taking me so long, because I am, coding all the regulations from 1926 on to 20. I'm going to stop in 2015 for complexity. I do believe a lot of financial innovation is not original. Merton Miller said this decades ago. Financial innovation is to avoid regulations. Some, not all, and not all of the evasions of regulation are bad. The problem is when they get people become too enthused about them, and we get too much of them, right, or over leverage of these new products. I That the point about dynamic uncertainty is regulators are always playing catch up because the innovation is before them. So I think that is inevitable, but I am not sure the complexity of regulation helps, right? And in fact, it creates legal uncertainty. It makes compliance extraordinarily difficult. Banks don't know what they're doing. And so I think a simpler system is better. One could argue, I think Andrew Haldane has, certainly I'm blanking on the name of the person in the US who had been an FDIC commissioner, on if you look at what Basel II and III are, they're incredibly long and detailed, and a simple leverage ratio is easier for people to understand and follow. It's not risk-based, but maybe that would, why, the argument, I guess, is you're suggesting, oh, we had to become more complex because the world is more complex, but sometimes, we might be better off with, moving to simple, I'm not going to advocate that all the time, but I'm just suggesting that I agree that that is an issue, but just because the world is complex doesn't mean the regulations are always better off being complex as opposed to being rethought. And let's get rid of the old ones that are surplusage, that are just confusing, and have a more compact sort of new approach to what we need to worry about now. But, good question.
Great. So the next question comes from Tom Voss. So I think we all accept, by the way, I think so far everybody accepts the Iron Law. We are really talking about the implications now. So Tom Voss asks, really interesting presentation. I wonder about the right policy conclusion. What if crises are essential to overcome lobbying by banks and crisis-driven legislation, which you show exists, is actually efficient or necessary?
So I have no objection to that sort of point, but my point on sunsetting does not. And so if we think about where lobbying of banks is important, it's also very important in the regulatory process, which no one pays attention to, right? Or very few, the press and the public doesn't pay attention to. So the idea of sunsetting, right, is that would be an effective sunset has whether it's a national commission or whatever you want to call it, a commission that has bipartisan experts that evaluates the laws, and then Congress has to respond and hold hearings, and that will get a lot of salience. So if the banks are lobbying or whatever they've done before, if that's we think that the regulations, and of course, let me caveat that with not everything that banks want is bad for the public, right? So, but putting that aside, if we thought everything they wanted was against the public interest, the sunsetting idea would make it more prominent. And if things that the regulators have done, if they were captured, that would come to the fore. If they weren't, if the regulations were fine, then, they wouldn't be gotten rid of. I know I'm talking about something that I didn't talk about, so that's probably unfair to my audience and the questioners. But my view about this would be that the legislation in sunsetting, it doesn't mean that it goes away and it's just repealed. It gives you the opportunity to revisit. It gets rid of the status quo by saying it's repealed if you don't reenact it. But the idea here would be that we might revise parts. We might reenact parts unchanged, and some parts we might get rid of, and some parts we'll just revise. And so if the problem was banks lobbying was creating an inefficient regime, that doesn't mean that the lack of their lobbying or their less importance in crisis doesn't make crisis legislation doesn't make it efficient. The review of it should get rid of the inefficiencies in the parts that were bank oriented that weren't. So that would sort of be a very quick and quick answer to try to get to that question.
So we have one more question by Marcus Roos. So he says, thank you very much for an extremely interesting presentation. To what extent are your findings of the characteristics of crisis-driven regulation of the financial sector relevant to other industry regulation, ? Specifically to the current developments of tech sector regulation in the wake of the misinformation of foreign intervention crisis of the 2016 election. I mean, Franklin raised a similar point, but he kept it with other financial regulation. So this goes even broader and asks, does the Iron Law apply to other kind of crises as well?
So I would not want to, though it may well, I would not want to sort of push that out of what I know something about. I thought, Franklin, your points about securities regulation were extraordinarily interesting, and I really need to think about them and that difference. Obviously it's oriented very differently. It's a disclosure system. It's protecting investors. It's not really a supervisory system on some of the statutes, and I need to think about it. But I should note there are law professors who say there is kind of, securities laws only get adopted at Congress after a crisis. But of course, that's not the same as what I'm arguing about what the nature of those laws are. So it's possible that these, even going beyond financial legislation, that there may, if we look at the regulatory system in the US, it's gone up and up, whether or not there is a crisis. So that may be true, but I am going to stick to my area, which I have at least, I think, some expertise, or if I don't have expertise, it's what I've been looking at.